Hi friends, Tony DeWitt here, Missouri appellate attorney and a guy who likes to make the law make sense on YouTube. Here's what we're discussing today. I'm back from Florida where spring break is going on. This beautiful beach back here behind me, suffice it to say it does not look like this at the moment. It is overrun with people between the ages of 17 and 25 and people are pretty much generally acting the fool out there. The water temperature is about 68 degrees, and people are getting in there and acting like it's warm. So you have to assume that alcohol has some kind of antifreeze quality to it. So I'm guessing that it seems to be working. The last couple of days that we were down there, the weather was so stormy that there were red flags up on the beach. And of course, red flags mean that you shouldn't go into the water. Even if you're an expert swimmer, you shouldn't go into the water. There were people in the water. Double red flags mean that it is unlawful to go into the water. And if you get yourself swept out in a riptide, you're either going to die or they're going to send the sheriffs out to get you in a boat, and then you're going to get fined $500. Either way, it's sort of a lose-lose, and people really ought to stay out of the water in that condition, but they don't. So today I wanted to talk a little bit more about the Hannah Gutierrez Reed case. I'm still troubled by the outcome, and I want to point out a couple of things. Y'all can feel free to disagree with me on this, but the first thing I want to point out is this: the charge of tampering with evidence was dismissed by the jury. They didn't buy into that, and they didn't buy into it because there was no proof of what was in that baggie. Now, we can all have a general belief that it had something in it, but a general belief is not proof. And the woman who testified, she couldn't establish that it was what she said it was, which was an unlawful controlled substance. And she didn't say that she had tasted that controlled substance and it tasted just like the controlled substance that she used to use. But the bottom line is the jury was never going to buy that. So in that situation, why do you charge it? Why do you offer the evidence knowing you're going to lose? There really is only one reason to do that, and the reason to do that is to throw some dirt on the defendant, make her look like a bad person. Now, maybe she is a bad person, I don't know. But generally speaking, courts try to keep things, what would otherwise be an uncharged offense, out of evidence. So, for example, if the prosecutor had properly analyzed this and said, there is no way we're going to get a conviction because we can't prove what that substance was, so we won't charge it, then at trial they couldn't have come in and said, but she had this baggie. And the reason they couldn't have done that is because evidence of uncharged crimes is inadmissible, unless it's used to show motive, intent, unusual common scheme or plan, that sort of thing. At any rate, they shouldn't have put that evidence in. And I think that the only reason they did that was, like I said, to trash the defendant. Now, did that result in the conviction? I don't know. It could have been that ridiculous gun expert that they brought in. But the fact of the matter is, the jury had enough evidence to render a verdict on involuntary manslaughter because they were not properly instructed and because the court did not properly dismiss the indictment or the information prior to trial. Now, why am I saying that's error? Well, the first reason it was error, in my opinion, is because of the doctrine of intervening cause. Now, under New Mexico law, involuntary manslaughter, where you essentially act in a way where you don't commit an unlawful act, in other words, loading that pistol was not an unlawful act, but you fail to use due care, circumspection, that sort of thing, that embodies criminal negligence. And criminal negligence embodies recklessness and willful and wanton. Well, it wasn't willful. She had no intent to hurt anybody. It wasn't wanton, lacking in moral lacking in morality. You could make the argument that it was reckless. I think that's the case. And I think if there was a conviction, that was why it came in, because they felt like she was reckless in not properly checking the gun. And she certainly should have properly checked the weapon. In her defense, she's 24. She's got a big star yelling at her because she's not moving fast enough. The prosecution's own witnesses established that. And as a result of that, safety on that set, particularly gun safety on that set, was terrible. And there should have been, and there was, fines that came in from the government for the fact that it was not a safe environment. And I think getting those people in on the defense side was probably pretty good. I think where they goofed up was in bringing in that crusty old guy who was the investment banker and talked about firearms, made that ridiculous argument about standing at port arms and order arms and that sort of thing, which are both rifle maneuvers, and this was not a rifle, this was a pistol. Again, I don't really understand where that guy was going. I thought his testimony was difficult to follow, and he didn't do a very good job of explaining what his theories were. That said, we get back to this issue of criminal negligence. One of the defenses to a charge of negligence is failure of proximate cause. Now, before we get to that, we have to acknowledge up front that it does not have to be the sole cause of the death. Her acts don't have to be the sole cause. So it's perfectly feasible to charge her and charge Alec Baldwin, which is what they've done. The problem is that the doctrine of intervening cause comes into play in two situations here. The first is that she had to believe, or at least expect, it had to be reasonably foreseeable to her that Alec Baldwin would point a loaded weapon at the cinematographer. That had to be reasonably foreseeable. It had to be reasonably foreseeable that he would not keep his finger off the trigger. It had to be reasonably foreseeable that he would pull the hammer back and let it fly with the trigger pulled and shoot the woman. All of those things had to be reasonably foreseeable, and I think a 24-year-old woman working for her first time as an armor on this set, I think for the most part, it's not reasonable for her to foresee all of that. But even if it was reasonably foreseeable for her to see that, we then have to go to the next level, because as I've said before, this woman was intubated in the esophagus, and an esophageal intubation blows air into the stomach, and it doesn't allow for air to get into the lungs except when the patient moves their diaphragm. And of course, when they are in deep doo-doo like this woman was, and she had lost a lot of blood, my guess is she wasn't breathing spontaneously on her own. So the question is, would she have survived if she had been properly intubated and arrived from life flight having been properly intubated with volume expanders and all of the other things that they could have done to buck up the blood pressure? And I don't know that the answer to that is yes, but certainly if they are going to charge Hannah Gutierrez Reed with negligent homicide, then it's reasonable to expect that they would have charged the people who didn't do what they knew to do, which is check that intubation. Now, I'm not suggesting that those people should have been. I'm simply pointing out that just like with Seth Kenney, where they decided not to charge that person, the question comes in as to just who the government's making deals with here, and are they making deals with the right people? So I have concerns in that regard. If I were representing her on appeal, I would start with the issue of intervening cause and proximate cause, and I would argue that to death in my brief. And I would use every example I could think of. And then the second thing I would put in there, I would also argue that they messed up in putting in this tampering with evidence issue because they were never able to sustain what the substance was that was in that bag. Now, all that said, do I think that Hannah Gutierrez Reed is going to get a free pass at the appellate court? I don't think so. An appellate court might be inclined, if it was a very liberal court, to look at her age and look at her limited knowledge of having worked in Hollywood, the fact that she didn't have as many films under her belt as the prosecution's expert witness. I think that would come into play. And I am sure there were a number of other evidentiary errors. And one of those evidentiary errors was the testimony of the EMT. Now, they called her the medic, but she wasn't a medic. She was an EMT. And her very emotional testimony about how, the little boy wasn't going to have a mama anymore, I felt like that was over the top. The judge did too. But again, once it's heard, once it's in there, how are you going to take that out of the jurors' minds? And so the judge should have, at that point, granted a mistrial. I'm sure that's what they went up there and asked for, but they didn't get it. Now, the prosecutor is running around touting how, what a great day for justice this is. I don't necessarily think that's so. I think that real justice in this case probably would have been achieved even if she had not been convicted. I suspect that she will never work again in Hollywood. And now, of course, she has a conviction for a felony, and she will never again be able to possess or use firearms. And so, in most respects, they have put her out of work, and she's going to have to go find a real job somewhere when and if she gets out of prison. And whenever that is, she's going to have a conviction, so she's going to be difficult to employ. You can't employ somebody like that in a position of trust. She can't be a teller at a bank. She can't be somebody who works in a law firm as a paralegal, because those people have to be bonded, and no bonding company is going to bond that person. And that's just common sense. Nobody is going to take a chance on a convicted felon. And unfortunately, that's what she's going to be. Even though I don't think she had felonious intent, even though it was a moment of, I'm sure, great frustration trying to meet this guy's needs, the only real question that I have is why it was necessary to even put any rounds into that pistol when all he was doing was rehearsing how the shot was going to be done. But that is another question for another day. That's my take on Hannah Gutierrez Reed. That's my recap. I do think she has probably a 30% chance of getting a reversal on appeal. But as my boss used to tell me, that the real secret to success on appeal is to represent the winner at the trial court. And I think that is often the case, because the presumption is, by appellate courts, that trial judges who are the closest to the evidence, they are the closest to the jury, they are the people who can really evaluate a witness's credibility, because all a appellate court is doing is they're reading a cold record, right? They don't have they don't have the trial on video that they can watch. I mean, I guess if they went to YouTube they could, but the actual record is on the transcript, and the transcript is what would control. So to me, you don't want appellate courts judging credibility because they weren't there. Because of all of that, I think that the chance is there, but it's limited. We'll just have to see how the appellate courts in New Mexico handle that. Well, that's what I have for you today. Thank you very much for watching. I am going to take another little bit of time here in a moment and do a video on the James Crumbley trial. That's what I have for you today. Thank you so much for watching. If you have the opportunity today, do something kind for someone. Overtip a waitress. Maybe buy your coworker lunch or something like that. Just do a random act of kindness. It does make the world a better place. And then catch me down here at the beach again tomorrow. If you like this video, here are a few others you might try, and don't forget to subscribe. Have a terrific day, guys.